Simpson, Patsy McGlone, Edwin Poots. Are there any other apologies? Okay. Agenda item 2 then is the draft minutes of the meeting held on the 18th of March. If you go to pages 5 to 10 of your meeting folders, if you want to indicate if you're happy enough for me to sign off. Happy enough? Yeah. Okay. Okay, agenda item 3, matters arising. Can I refer to pages 12 and 13 of the meeting folder. The Department has written indicating that the Minister has requested officials spend more time finalising the summary of the consultation responses on the criminal law on abortion in cases of lethal fetal abnormality and sexual crime, which is lengthy and, given the sensitive nature of the issue, requires careful editing to ensure the range of views expressed are properly reflected and a balanced and accurate account of the responses are provided. The oral briefing scheduled for today, therefore, has been postponed and will be rescheduled after the Easter recess. Item 2 is the Committee Forward Work Programme. A copy of the Department's planned work schedule for April is included in the table pack, pages 3 and 4. The schedule outlines the oral and written briefings, and the Department's planning to provide the Committee in April, but the timings of some of these still have to be finalised. In addition to those, the Committee has also agreed a number of other oral briefings that need to be scheduled, including briefings on the shooting issue and also the informal public hearing in the Senate in relation to the proposed closure of the courthouses. The Committee also, obviously the Westminster election 7th of May, so the Committee won't be meeting that day. I would also propose, if members are in agreement, the Thursday before that, the 30th of April, that we don't meet unless there's anything urgent comes up. It's always difficult the week before an election to get quorum, and I know there's a few candidates and members of the committee and things like that. So if members are in agreement, then we'll not meet the week before the election unless anything urgent comes up. Happy enough?
Happy days.
Yeah. Okay. Agenda item 4 then is the statutory time limits. So officials will attend to discuss proposals for the introduction of statutory time limits, the relevant papers, including a copy of the Department briefing paper, pages 15 through to 80 of the meeting folder. So if the officials want to join us at the table whenever they're ready. Okay, can I welcome Maura Campbell, Graham Walker, Jean Moore, being recorded in Hansard and will appear on the website in due course. So whenever you're ready, if you want to brief us, and we'll open up for questions afterwards. So.
Thanks very much, Chairman. We're here today to update members following the briefing we provided back in September on the outcome of consultation on a statutory time limit scheme for the Youth Court. Since then, we've reflected on the issues raised by members, which ranged from concerns about the risks to victims of introducing such a scheme through to a view that we perhaps needed to be more ambitious if we're going to make a meaningful change in the time taken to progress cases involving young people. We're very grateful to members for taking the time to discuss these issues in more depth with us, with a view to identifying a way forward that might be capable of achieving a stronger consensus. We've also had the benefit of further meetings with a number of stakeholder organisations, and we found the further engagement with them to be very constructive as well. From these discussions, we found that there was strong agreement for the principle that victims should not be adversely impacted by the introduction of statutory time limits, either because of cases not proceeding or because the time limits resulted in delay simply being displaced. And we also established that while a number of stakeholders remain firmly of the view that we should be introducing time limits on the basis recommended by the Youth Justice Review, they could accept that this may need to be achieved on a phased basis, provided we set out very clearly our commitment to building on our current proposals and how exactly that would be achieved. So in order to demonstrate that commitment, the Minister has written personally to you in advance of today's briefing, and his letter includes at Annex A a timeline setting out key milestones for the introduction and review of a statutory time limit scheme. The letter also sets out how we'll seek to ensure that the rights of victims and witnesses and the interests of justice will be protected. We've been working with the PPS to analyse how we would have performed against the time limit had it been in place during 2014-15, with a view to seeing what factors were contributing to delays in the cases where the limit would have been exceeded. In the cases we've reviewed so far, which were the cases up to the end of December 2014, 87% of those cases would have met the time limit. The review of sample cases indicates that the most common reasons for cases being delayed in the remaining 13% of cases were outstanding forensic or medical reports or delays in obtaining CCTV evidence, and the next biggest factor was the summons not being served on the first attempt. But a range of other issues were also identified, including difficulties in getting witnesses to attend and non-appearances by the young defendant. As we finalise this exercise, we'll be working with the agencies to see what more can be done to address these issues, and we'll also continue to monitor actual performance very closely, including performance in cases involving excluded offences. In terms of the next steps, and subject to the committee's views today, what we plan to do is to revert to stakeholders for a pre-consultation on options for an administrative time limit for the earlier part of the process, and for a new statutory start point for summons cases, to circulate a report on our analysis of performance during 2014-15, the exercise I mentioned earlier, to finalise and lay draft regulations for an initial STL scheme, to introduce the initial scheme by the autumn, and at the same time launch a public consultation on options for the earlier statutory start point. Looking slightly further ahead, we plan to undertake a formal review of the STL schemes after it's been in operation for 12 months, as part of our roadmap to an extended scheme, which will look again at the duration of the time limit, the excluded offences, and the use that's being made of extensions. And we'd be very happy to take any further questions.
Okay, thank you very much. I just first of all say, I think you mentioned at the very beginning that most people would agree with the theory behind this, and I certainly believe that the shorter the time between the alleged offence and the punishment, the better, because it links the two things together, particularly for young people. I think there's a body of evidence out there to suggest that that's the case. I know that the last time you came to the committee there was concerns around whether or not, if the 120 days was breached, whether or not the young person potentially could drop off and escape justice as a consequence. And I think you've clarified some of those issues. Perhaps if you could just go through for the benefit of the committee. First of all, I know you've given us a list of all of the offences excluded from the scheme, so the more serious offences, such as violent offences, sexual offences, things like that. What sort of offences are we talking about that would be included in the scheme?
Yes, as you say, Chair, a number of offences, such as serious sexual or violent offences, are going to be excluded because those are the types of offences that would have the greatest impact on victims. In terms of the types of offences we're talking about, we've got a good feel of that from the review we've done. Actually, a lot of the time it's things like criminal damage and theft and lower level assault, I suppose, would be types of offences we're talking about.
Yeah. In 2014, the types of offences most commonly prosecuted were common assault at 14%, criminal damage 13%, disorderly behaviour 8%, theft 8%, and assault on police 7%. Now, there's a huge list of offences, but those are the offences that are at the top of it in terms of recurring regularly.
And in terms of the 13% of cases that aren't currently within the 120 days, is there any indication of the nature of those offences? I know you said about the delays are caused by getting CCTV evidence and forensic reports and things like that. Is there any sort of theme in terms of the types of offences that currently aren't making it through in time?
That was something we
looked
to see, was that the case, and were the offences that would be excluded the ones that were always, coming in over the 120 days. We didn't see a clear pattern in terms of offence type. We've found a sort of a mix of offence types among those that were exceeding the 120 days, which I think suggests to us that we can't make any assumptions that if it's a particular type of offence, it's going to go through more quickly or take longer. And it just reinforces for us that there's going to be a need to very proactively manage all of the cases and monitor very closely how all of them are proceeding.
And talk me through, so the 120 days, if a case has not come to a conclusion after the 120 days, what happens?
Well, after the 120 days, I think there was a concern in some parts that maybe cases would collapse at that point, but what would happen in practice is that those cases would be stayed rather than being discontinued, and there would be a 3-month window in which the Director of Public Prosecutions could reinstitute proceedings. And even if a judge doesn't allow for the recommencement of proceedings, there's an appeal mechanism, and we would have thought that the type of factor that a judge would take into account in deciding whether or not to grant the extension or to allow for the reinstitution would be the impact on the victim. There's also the potential for the prosecutor to apply for an extension so that you don't reach the point where the time limit is exhausted. You are given that extra time rather than having to stay the case. And again, we would think that the impact on a victim would be a key consideration in those circumstances.
Is there a danger that the courts will get clogged up with applications for extensions?
Obviously,
why wouldn't that happen?
That's something we wouldn't want to see happening, because you're just facing one form of delay with another, which is why we'd looked at actual performance when setting the duration, and we think 120 days, there's a bit of challenge in there because there are a number of cases that aren't meeting that at the moment, but it's not so short that there would have to be continual applications for extensions.
And what circumstances would a court refuse to grant an extension? So, I mean, the reassurance for the committee is that, like, if the 120 days is breached, there are safeguards there to ensure that young people don't escape justice. In what circumstances would a court say, well, no, we're not going to grant an extension, we're not going to allow extra time for this to come through?
Obviously, it'll be a matter for the judge in the case, and we're always very careful not to cut across judicial independence or judicial discretion. But I would have thought a judge would probably take a dimmer view of the delay if he or she felt that best efforts hadn't been made by the agencies to take the case forward in ways that were within their control. If there was some factor that they couldn't control, I would have thought that in the interest of victims and witnesses, the judge may be inclined to allow a bit of extra time. But the sort of thing that we can look at here is, you know, if we see that things like forensics medicals are an issue, we'll need to build in better case tracking to ensure that those don't end up creating the conditions where an extension is going to be needed.
And just in terms of definition, it says about in the interest of justice, so that the judge would allow an extension in the interest of justice. Has there been any consideration given to a definition for the interest of justice? Because it seems a fairly subjective type of phrase to use.
It's an issue that came up in the consultation on the Justice Bill as well, where there were suggestions made about whether or not in the interest of justice is the right sort of test to be using when you're looking at measures that are designed to tackle delay. The feedback we got from consultees, though, was that seems to be a well-established principle which is generally well understood, particularly among the legal profession.
The difficulty is, Chair, that, I mean, in an individual case, what may be in the interest of justice may vary. As Laura says, it is a test that is well established and is understood by the judiciary, and it's something that they would deal with on a fairly regular basis.
Okay. Raymond?
Thank you very much. Just in relation to the 87% of cases now that are going through, that's without any sort of demand or any statutory provision?
Yes, that's in the absence of a statutory time limit. So we're hoping that the fact there is a statutory time limit will mean that performance should improve.
And in terms of, say, a comparison, I mean, this provision is already in place in Scotland?
There's a similar scheme, yeah. But the system operates quite differently in Scotland, so it's difficult to make direct comparisons.
Would there be any percentage comparison which many of their cases slip as a result?
I don't have that.
Okay, that's okay. No, that's fine.
I don't have that detail, but we understand that in Scotland, because they've been operating on the basis of a statutory scheme for a very long period of time, that it's just custom and practice now, and we're not aware of it having created any particular difficulties.
But you would expect, with the statutory provision, that the 87% would increase?
Yes, we're hopeful it would be.
In terms of the particular analysis around the presentation of the case, I think there's 4 categories: forensics, medical evidence, CCTV and summons. Yeah. Is there a particular analysis as to why it's them? You know, is there not enough forensics, or the medical evidence, is it down to, you know, expert witnesses, or is it just down to doctors' reports? Or
I think it's, it's been an issue that we've been aware of for a while that, for instance, medical reports can take some time to get. But I suppose, again, it's making those responsible for producing those reports aware that a clock is ticking, so it may help to put a bit of extra pressure on to get those in on time. On the forensic side, there's a forensic strategy in place now which is seeking to make a number of improvements around submissions and processing times for forensics. Sometimes what you'll have is if there's a large spike in submissions in a particular discipline, like biology, for instance, or drugs and toxicology, that can slow things down a bit. But I suppose we will be looking to see what more can be done to ensure that the cases that are subject to the time limit can be identified, flagged and tracked so that hopefully those will be given a higher priority.
You see, the reason why I'm asking is, like, will somewhere along the line, say this is in place, like be a case review where perhaps, CCTV footage is something which puts you beyond the limit, but, a prosecutor might say, I have a strong enough case, I don't have to witness CCTV, where now you could see the temptation would be, you're not under any pressure with all the evidence is there and it's a more complete case, but you might have a case where it's coming to, let's say, the 90 days and someone steps in and says, well, what will CCTV add to this case? It may not be necessary. So will that type of procedure be in place?
I think that's a very good point, actually, about thinking at an earlier stage about what evidence is required. And certainly, well, you heard the Lord Chief Justice mention last week about the ARDS pilot. What we've been finding in that is that where there's earlier engagement between police and prosecutors, we're been able to reduce the number of requests for submissions, like forensic submissions. And hopefully also we could look at, another issue that was highlighted was witness attendance. Do all of those witnesses need to be there for the case, or could the case proceed with fewer witnesses being called? So I think it's a good opportunity actually to pursue those sorts of issues.
And in terms of the summons issue, what piece of work will be undertaken there to improve that? If that's adding to your sort of, we have no percentage breakdown of those four categories, but even if it's 3 or 4% of your cases, what work will be done to try and tighten up the procedure of summons?
I think the key thing with summons will be, at the moment there's a bit of a lag. If it doesn't succeed in the first attempt, it tends to take a while before a second attempt is made. So I think what we'll be seeking to do is reduce the time taken to reissue the summons. Now, some of the changes we're making through the Justice Bill will assist with that as well, in that it'll provide for electronic issue of summons and for the summons to be signed by a prosecutor rather than a lay magistrate. At the moment, it would have to go back a second time to a lay magistrate to be signed.
And the delay at present, it's just the inability to get the person, or is it other issues?
It's largely around service in terms of finding the person.
Yeah.
So there's generally 2 attempts made at postal. On occasions, there's delay perhaps in identifying a second address to try for your second attempt. So rather than post it out exactly the same way the second time, there's some checking done. So things like that perhaps could be, tightened to get the summons out more quickly.
But going back to the point made by the Chair earlier, if you tighten things up more generally, if the investigative stage is shorter, it should take less time to be issuing the summons. There's less of a risk that someone will have moved elsewhere, and they should be easier to locate.
See, I think, in broad terms, this is a positive move, because I think we all have heard over the years evidence that the quicker a young person's in the system, particularly the first time, the quicker in, the quicker out of it, then the better chance they have of being out of it completely. So whatever we can do to sort of push that down, and I think that's a. What would your hope be from 120-day limit in terms of percentage? What would you like to see the 87% becoming?
Well, as close to 100% as we can achieve, but it's very difficult to say what we'll actually achieve.
You would want to see a marked increase. You'd want to see something different.
We would like to see it the norm that 120 days would be the maximum amount of time it would take. We'd still like some cases to come in even quicker than that. We don't want that to be necessarily the standard. It should be very much the maximum, and if there's the scope to get cases through more quickly, we'd want to see that happen as well.
Because if 13% of your cases were stayed, then you can see how the clothes could be clogged up, and that's horrible. Okay. Thank you.
Tom?
Chair, thank you, and apologies for missing the presentation. You'll appreciate that I have still concerns around the 120 days and that it's not implementing the Youth Justice Review proposals. However, I'm obviously conscious of the difficulties that's posed with it, because it's not, that 120 days isn't from arrest to disposal, and I've said to you before I would prefer that time limit was actually increased to 160 or 180 days to start with, and then try and work it back, as opposed to start at a later time. And you did assure me of the administrative time limit, but I see it mentioned in your document, but I don't see any indication of what those time limits are in the administrative process.
The administrative process in relation to charge cases, we would see the start point for that being the point of arrest, and what we'll be consulting with stakeholders on is for a comparable start point for an administrative time limit for summons cases. So it would cover the amount of time that the Youth Justice were talking about, albeit initially on an administrative basis, but then we would move to make that statutory as well. But I think part of the key feedback from stakeholders was if the focus only starts to be applied at the point where we're currently starting the statutory time limit, there is a risk that there's a chunk of time at the very start of the process that could be ignored, and we fully take on board that point and that concern. So we're hoping that by creating the administrative time limit, we'll retain the focus on that, and we'll be monitoring that closely and reporting on that to the Criminal Justice Board.
How will that administrative time limit feed into the summons cases? Because that appears to be where there's a significant problem. So how will it help to resolve that?
I suppose in general terms, as well, at that point in the process, I think it's the fact that in a charge case, generally, you've 28 days to proceed on a charge case. With summons, it's more open-ended. So we're hoping that having an administrative time limit in place will actually mean a bit more attention is paid to general timeliness for a summons case. We did find that the bulk of the delay in summons cases was actually at the point that is covered by the statutory time limit, because that encompasses the attempts at service of summons, which is where we've had the issues that we were discussing with Mr McCartney around if it's not served first time, then subsequent attempts can take quite a bit of time to prove successful.
Yeah. But I'm not so sure that the process that you're suggesting will actually resolve that part of the issue, will it? That if the summons isn't served the first time, then what is the impetus then to make it speed up to get it served, to get the summons served?
I think it's really to ensure that the second attempt at service happens more quickly than it does at the moment. There can sometimes be a bit of a lag when it's been unsuccessful in the first attempt before a second attempt is made. But we can see the scope to actually shorten that time period down.
Yeah, but again, getting back, I don't think we're cross purposes here. I'm trying to say, is what you're proposing helping that situation and putting pressure to get that someone served who was not served the first time?
I think the original scheme that we proposed, which we're now supplementing, was encompassed in that part of the process anyway. So what we're talking about now isn't going to, the addition of the administrative time limit isn't really seeking to address the issue that you're talking about there, because that would already have been within the scope of the statutory time limit scheme that we were originally talking about.
The period of summons service would be covered by the statutory time limit as it stands, because STL statutory time limit and summons run from when the complaint is made.
Yeah, okay.
Once the complaint has been made, and the PPS endeavour to have the summons served, so the clock is effectively running for that period.
But the pressure of the STL, or the STL creates a pressure in terms of the agencies working together to identify either a fresh address for a young person to track them down, or to undertake work more quickly to try and identify where they might be.
Okay, so it is actually effectively dealing with that part of the process.
But yeah, it'll create a pressure to do that work more quickly, because there will be a time.
Okay. If that pressure doesn't work, what's the outfall from that? In other words, if it doesn't happen more quickly? If your review finds that it's not happening more quickly?
Yeah. Well, one other thing we've been discussing with the agencies is whether summons is always the best approach to be taken in cases. There are some cases that are lower level where it is more appropriate because there are consequences for a young person if you go down the arrest and charge route. But we think there may be cases at the moment that charge may be more suitable for if it's a prolific offender and if it's a more serious offence, then charge is the route that should be being used, so that you reduce the number of cases that would proceed by way of summons. We're hopeful also that youth engagement, by diverting more of the lower level cases away from the courts at an earlier stage, should be taken out some of the cases that traditionally would have proceeded by way of summons. So at the moment, before we started down the route of youth engagement, about 2/3 of cases involving young people were proceeding by way of summons. We'd like to see that proportion significantly reduce. And then you've less of the to-in and fro-in with trying to reattempt the summons, so it should be easier to speed that up.
Okay, thank you. Thanks, Chair.
Okay, Sammy?
Thank you, Chair, and thank you for your presentation so far. The Minister has said that he doesn't believe that the system is ready for those proposals by the Youth Justice Review. And then he goes on to talk about the phased approach to STLs and his plans to introduce an STL scheme by October. So what will change between now and October? I know it's a phased system. Why if it can't do it now that we're able to do this new system by October? Or maybe could you just elaborate a wee bit more about why the system isn't ready at this stage?
I think the Minister's concern is that if you were to introduce 120 days end-to-end for youth cases, that would be overly ambitious for us at the moment and would create too many risks in terms of potential impact on victims and the issue we were discussing earlier about just replacing one form of delay with another when you've lots of applications for extensions or reinstitution of proceedings. So what we're proposing is that the statutory element of this should be 120 days, but should cover a shorter part of the process, and then we build out from that to hopefully, over time, have a more end-to-end system of a shorter duration. So I think that's what we mean by sort of phasing this in. We found when we talked to stakeholders that they still would like us to meet the recommendation in the Youth Justice Review, but there was a willingness to work with us to look at how we could stage this in such a way that that could be achieved. Rather than taking an all-or-nothing approach, let's start with something, let's acclimatise the system to having the rigour of having statutory time limits in place and then build progressively on that.
And again, do you have any other examples in any other jurisdiction?
They did pilot or did look at the use of statutory time limits in England and Wales, but other than, I think, custody time limits, they didn't pursue that. Scotland, as was mentioned earlier, do have statutory time limits in place and have had for quite a considerable amount of time, and they seem to work quite well in that jurisdiction, albeit because their systems and processes are very different from ours. It's very difficult to make a direct read across.
Thank you, Chair.
Okay. Anyone else indicated? No? Okay. Thank you very much. Thank you.
Thank you.
Sure. No problem. Okay, members. I think we're generally content then with the department's proposals, all right? Any further information required or information helping out? Okay. Move on then to agenda item 5, Justice Bill, approval of the committee report. We should have that with them, do they? Provided electronically and in hard copy. Typos and formatting errors will be amended at the proofing stage of the report. But can I just ask, first of all, if members have had a chance to go through it, are there any amendments that they're proposing at this stage, or are we happy to go through it and just agree as we go through? Okay. Then can I refer members to the title page, committee membership and powers, table of contents, list of abbreviations at the front of the report, and just put the question formally: are members content that the title page, committee membership and powers, table of contents, list of abbreviations stand part of the report? Okay. Okay. Can I refer to the introduction section, paragraphs 1 through to 22? Put the question: are members content that the introduction at paragraphs 1 to 22 stand part of the report? Agreed?
Yeah.
Great.
Refer to the consideration of the bill section of the report, paragraphs 23 through to 309. I'll put the question: are members content that the section of the consideration of the bill of paragraphs 23 to 309 stand part of the report?
Okay.
Agreed? Okay. I refer members to the consideration of new provisions for inclusion in the bill section of the report at paragraphs 310 to 383. I'll put the question: are members content that the section of the consideration of new provisions for inclusion in the bill section at paragraphs 310 to 383 stand part of the report? Agreed? Okay. Refer to the clause-by-clause consideration section of the report, paragraphs 384 to 518. And again, I'll put the question: are members content that the section on the clause-by-clause consideration of the bill at paragraphs 384 to 518 stand part of the report? Agreed? Speak up, members.
Great.
Okay. Can I, sorry,
Chair,
yeah.
just, they say me looking for this, where there was a recorded vote, that's in the report?
If the recorded vote is in the minutes of proceedings, which isn't
That's right.
in
That's
the
okay.
report, at that part there, it also records where there was a proposal. At paragraph 389, it records there was a proposal, the proposed amendment by Jim Wells, and was agreed by a majority of members.
Okay, that's
And
great, that's
then,
fine, that's great, that's great.
The previous paragraph outlines the proposal that you put forward.
Okay, that's fine, that's fine.
And it was not supported by a majority of members. The actual recording of the vote is in
Okay.
the proceedings, Appendix 1.
That's great. Thank you.
I refer members to appendices 1 to 10 of the report, which include the minutes of proceedings, the minutes of evidence, the written submissions, memoranda and correspondence from the Department of Justice, correspondence relating to the Attorney General's proposed amendment to the Coroners Act, correspondence relating to the Attorney General's proposed amendment on rights of audience for lawyers working in his office, correspondence relating to the proposed amendment by Mr Jim Wells, the Assembly research papers and other correspondence considered by the committee, and then there's a list of witnesses as well. So can I put the question: are members content that the appendices stand part of the report? Okay, can I refer you to the executive summary of the report? It's just been handed to you. Okay. Right, okay. If members are content, then just if they want to go through that just in the next few minutes, then we'll come back to it at the end of the committee meeting, if that's okay. Just to give everybody a chance to read through it, if that's all right. Happy enough?
Yep.
Okay.
Chair, I think the chances of people probably picking up much between now and the end of committee week is very limited.
What's in the executive summary is an exact lift for paragraphs in the
12,
report.
actual then?
Yeah, well, the wording is an exact lift of, it's just
That's okay.
summary and an exact lift of what's actually in the report. There hasn't been any changes made. Wording.
Look, I don't think, Chair, there's going to be any.
Happy enough to agree it now, then?
Yeah.
Yeah. Okay, then. Put the question: are members content with the executive summary? Stands part of the report. Agreed. Okay. And can I get agreement then for the committee for me to approve the relevant extract of today's minutes for inclusion in the printed report? Okay. And I'll put the question that the Committee for Justice is content for the report on the Justice Bill to be printed.
Yes.
Okay. And get agreement then to issue an electronic copy of the bill report to other organisations and individuals who provided evidence to the committee on the bill. Have enough? Okay, that finishes the committee stage of the Justice Bill. We can move on to agenda item 6. I refer members to pages 83, 92 of your meeting folders. You'll recall the meeting on the 18th of February 2014. The committee agreed that it was content with the proposed statutory rule to amend the Police Act 1997 Criminal Records Disclosure Amendment Regulations 2008 to enable Access NI to search for details of an individual's criminal record on the Police National Computer. The proposed rule also sets out details of the information that Access NI will provide where the individual's criminal record shows they have a restorative caution, a diversionary youth conference order or informed warning. The statutory rule number 2015/143 was laid by the Department of Justice on the 10th of March and is subject to the negative resolution procedure. There have been no changes to the policy content since the SL1 was submitted to the committee, and the examiner of statutory rules confirmed there is no issues to raise with regard to the technical aspects of the rules. So therefore, if members are content, I'll put the question that the Committee for Justice considered statutory rule number 2015/143, the Police Act 1997 Criminal Records Disclosure Amendment Regulations Northern Ireland 2015, and has no objection to the rule. Okay, if you agreed? Okay. Agenda item 7. I refer members to pages 94 through to 104 of the meeting folder. The Department has been continuing with its work to draft secondary legislation which will reform police discipline and unsatisfactory performance procedures in Northern Ireland. The new regulations will revoke and replace 4 existing sets of regulations governing conduct, performance and attendance and appeals procedures. The first draft regulations were provided to the committee in May 2013, and a 12-week targeted consultation with policing stakeholders followed. A written update was provided to the committee in December 2013. The Department has now provided an update on the proposed statutory rules and a summary of the key provisions. The 3 proposed statutory rules, which will be subject to the negative resolution procedure, make provision for the maintenance of discipline procedures for members of the PSNI. The reforms are based on good employment practice principles and aim to strengthen the role of supervisors and management in dealing with conduct and performance issues and allow them to deal with those issues proportionately and efficiently. All 3 sets of regulations issued for a second targeted consultation between August and November 2014. Since the last update, the regulations have been revised with particular emphasis on preserving the existing role of the Ombudsman in the processes. Other revisions to drafting include the provision for attendance at disciplinary proceedings, provisions for witnesses, transitional provisions, legal representation, timescales, the composition of panels across all 3 sets of regulations, and a provision for review of a police appeals tribunal determination in particular circumstances. Would members be content if we had an oral briefing from officials on this one? Yeah. Okay. Agenda item 8. Can I refer members to pages 106 to 163? The Department has provided its 6-monthly report on progress to reduce avoidable delay in the criminal justice system and the delivery of victim and witness strategy and action plan for 2013-15. The report sets out the range of work that has been taken forward on the issues that the Department will focus on over the next 6 months. The Department has provided the latest criminal justice system performance report covering the period April to December 2014, which shows improvements in end-to-end processing times in both the adult magistrates and youth courts compared with performance levels achieved in the previous year. Performance levels in the Crown Court are largely unchanged. Can I ask members, are you content to note the updates and delivery of the programme for work, or whether anybody has any views or comments to make? Happy enough to note? Okay, agenda item 9. Refer members to pages 165 through to 172. The Department has provided a written briefing paper in relation to the guidance and directions required for the implementation of the Civil Legal Services reforms. Section 3 of the Legal Aid and Courts Act, Northern Ireland 2014, provides for the Department to issue directions and guidance to the Director of Legal Aid Casework about the carrying out of the Director's functions. The Director must comply with such directions and must have regard to such guidance, and the Department cannot give a direction or guidance in relation to an individual case. Section 4 of the 2014 Act also gives the Department the power to require the Director to delegate or not to delegate particular functions. There are a number of pieces of guidance and directions in place under the current scheme, and the Department has envisaged that revised guidance and directions would be issued prior to the implementation of the Civil Legal Services reforms. The Department has highlighted that due to the work capacity issues within the Department, it's not been possible to bring forward the revised versions, and the Department is therefore asking the Director and Agency to have regard to the current materials. So again, can I ask members to note that position unless anybody has any comments or questions?
This has to be done in order to implement the new changes, but it doesn't really, there's no real policy change as such. Yeah.
My understanding is they need to update
Yeah.
all the guidance and directions to reflect the new changes. They just haven't had the capacity to do that. So the ones in place now, I think it was basically that's the ones in place now will apply until they get the revised ones.
Thank you very much, Chair.
Okay, thank you. Agenda item 10 then, can I refer members to pages 174 through to 206 of the folder. The committee commissioned a research paper to inform its consideration of the Fines and Enforcement Bill, which is now due for introduction in June. The paper provides comparative information on fine collection and enforcement systems in a number of jurisdictions, including England and Wales, Scotland and the Republic of Ireland, Australia and New Zealand. If members are content to read through that paper, but we'll maybe ask Fiona to come and brief the committee once the bill is closer, just to keep it fresh in the mind if members are happy enough for that approach. Okay, agenda item 11 then is correspondence. There's 8 items of correspondence at pages 208 to 267 in the meeting folder, and 4 items at pages 6 to 28 of the tabled pack. A couple which I will draw attention to. Item 2. Page 212 of the meeting folder is correspondence from the Committee for Education, requesting the views of the Committee on Justice on the Special Education Needs and Disability Bill. The SEND Bill completed its second stage on the 10th of March and has been passed to the Committee for Education to commence its committee stage. The bill includes provision relating to appeals to the SEND and Disability Tribunal, and in particular Clause 8, which requires would-be appellants to obtain advice of mediation and obtain a certificate to this effect prior to the appeal to the Tribunal. Are we happy enough to forward the correspondence to the Department for comment and then consider the matter further once we've received that response? Okay. Item 1 at page 6 of the tabled pack is correspondence from Brian Milford, Department Secretary of NIPSA, in relation to the briefing from the prison service officials back on the 4th of March. In the letter, he highlights that whilst the Director of the Prison Service advised the Committee during the oral evidence session, discussions are ongoing with NIPSA in relation to the ending of the issue of security notices to non-prison grade staff. No officials from the Prison Service have been in contact with NIPSA on the matter. Are we happy enough if we forward that correspondence to the Prison Service for comment and an explanation, and then consider how we deal with it once we get that response?
Yes, it's very unsatisfactory, though, that there hasn't been contact. You know, I can understand, you know, there's a volume of business, but it's an important issue to these staff. It really needs to be addressed.
Absolutely. Okay, so we'll forward that on. Item 2, page 7 of the table pack is correspondence from the Department in relation to the implementation of the Roe House Stocktake report. The response advises that the Prison Service continues to work towards the implementation of the 9 Stocktake recommendations, and it continues to view the implementation of the recommendations as the most pragmatic and practicable mechanism to achieve a more normalised regime in Roe House. Again, that's just for noting unless anybody requires any further information. Item 3, page 10 of the table pack, is correspondence from the Department in relation to the Crime and Courts Act 2013, National Crime Agency and Proceeds of Crime Order 2015. The correspondence advises that the order has now been passed at Westminster and the administrative elements of the order came into place on 20th of March 15. The operational provisions around the use of powers and privileges of a constable and investigatory activity by the National Crime Agency in Northern Ireland will come into effect in 2 months from the 20th of March. These will include the agreed provisions regarding accountability. So again, it's just for noting, unless anybody requires any further information. Item 4 is at page 24 of the table pack. Is a response from the Department in relation to taxi drivers and XSNI checks. I think Sammy had raised this issue at a previous meeting. The response indicates that there are 169 applications as of the 18th of March in relation to taxi drivers that have not yet been completed. XSNI is currently processing all applications for enhanced checks within 6 days of receipt, and of the 169 applications outstanding for taxi drivers, 69 have been with the police for over 60 days. The PSNI acknowledge that there is a backlog and the recovery plan has now been put in place. So, are we happy to note that unless anybody has any?
Well, I note the issue for taxi drivers. I'm assuming it's no different for other professions as well, that there's problems with. You know, again, I don't know what we can do, only note it, but What I would ask is that the police or the department give us an update after maybe another month or 2 months, whatever.
Yep.
I don't mind what time scale as long as it's within reason.
Sure.
To see actually how they're performing, if they're improving.
Yeah, happy enough to do that, yeah. Okay. Any comments on another piece of correspondence?
Just there was correspondence from a Mrs. McLaughlin in relation to animal cruelty issues, and I was just wondering, you know, we have, I know the Agriculture Committee has received similar correspondence, but it struck me as quite a difficult issue, and just wondering really if there was any solid piece of information coming back from the police or anybody else in relation to verifying our serious allegations. I was quite disturbed when I... I know in a way, Chair, that we pass these things on, but, and I don't want us to be bogged down in individual cases. It seemed to me to be an extraordinary state of affairs here, people saying that there was systematic animal cruelty ongoing and nothing was being done about it.
Look, if we get copied into the response, and then once we receive that,
Yes.
we could perhaps take a decision on what way we
Yes.
handle it,
Yes.
if members are happy enough with that approach at all.
Yeah.
Chair, it's been an ongoing dispute for some time, and I know McGuinness's colleague is involved as well, making representation as part of a delegation. I think it was from the Agricultural Committee. I can't remember which committee it was from. This was the Agricultural Committee that met with Mr. McLaughlin on it. It's a highly unusual case now.
Yeah.
I spoke to the police. I have correspondence from the police going back for some time on this one. And it's a really difficult one, I'm assuming, to solve. I think the police are at a loss as well regarding it all. Just don't know how you keep it momentum going, but you're right. If at least we're copied into something and maybe try to find out if the police have any leads at all, it might be useful.
Thank you very much, Chair.
Okay, no problem. Okay, members, agenda item 12, Chairman's business. Just a couple of things. I've been approached by a number of businesses and business organisations about the whole issue of business crime. I know a piece of work was done by the policing board a number of years ago. But the way that I propose to maybe deal with it is we'd agreed to do a sort of informal hearing about the courthouses. Thought about maybe setting aside a few hours to do something similar with some of the business organisations to hear about business crime, what their ask is. Now, some of them are asking for a more formalised structure. Others think that it can be dealt with between business organisations themselves and about sharing information. But if members are happy enough, we would organise a few hours to do a sort of event with some of the businesses and hear about their concerns around business crime. If people are happy enough with that, yeah. Okay. Then, the meeting on the 4th of March, the committee considered an invitation from the Law Society to attend an event in relation to the impact that legal aid cuts will have. The Law Society has advised the event, which was due to take place at the end of this week, has been postponed, and the Society remains committed to the event and will look at possible dates in the coming months and advise the committee of any new date. That letter is at page 30 of the table pack if anybody wants to read it. Agenda item 13 is any other business. Has anyone any other issues to raise? Sammy?
Sure, I mentioned last week about the search and rescue. I was very encouraged to see the Minister's response. I was down at Legan search and rescue last Sunday, and they certainly rescued me when I was in the middle of Legan. I lost my way. Or I went up my nose, but that's another story.
Go on ahead, we've plenty of time today.
So, but I was hugely impressed with the operation, and it must be the same in a lot of those organisations, and the sheer volume of voluntary work that's carried out there. So I was going to suggest that I'd love us to go and visit at some stage, maybe over this next number of months, whatever. But again, hugely impressed with what my colleague Paul had raised this. Fascinating. It's an aspect of the Justice Committee that I didn't think I'd be involved in until I came here. So.
Okay. Okay, well, look, we'll over Easter, when we look at any sort of visits, we'll plan the other side. There's been a few requests come in
Well,
to get the committee out and about and stuff, and even when we meet with some of these groups over lunch or in the formal lunch and then have our committee meeting, it's worked reasonably well in the last few times we've done it, so we'll have
Yeah,
it.
to that, Chair. Not only do they do invaluable work and save people's lives, if you're looking at it in a purely financial, budgetary aspect, they save the police an absolute fortune.
You made that point, yeah.
So, you know, we should be mindful of things like that when it comes to budgets and making sure that they are supported well enough to do their job, because the money they save the department and the police force.
Okay. Okay, then agenda item 14 is the date, time, place of the next meeting. The next meeting held on the 16th of April, 2 p.m, room 30 it will be. So that's us. Happy Easter, everyone. And
Okay.
nice, quick meeting.
This is the Northern Ireland Assembly Committee Room 21. This is the Northern Ireland Assembly Committee Room 21.